Companies Act Section 70, Prohibition for Buyback in Certain Circumstances. Overview of Section 70. Section 70 of the Companies Act outlines specific prohibitions regarding the buyback of a company's own shares or specified securities. The section aims to safeguard the financial integrity of companies by preventing buybacks under certain circumstances that could jeopardize their obligations to creditors and shareholders. The provisions herein are designed to promote responsible corporate behavior and ensure compliance with statutory requirements, thereby maintaining the trust of stakeholders in the financial markets. Key provisions of Section 70. 1. General prohibition on buyback. Under this section, a company is expressly prohibited from directly or indirectly purchasing its own shares or specified securities under the following conditions. Through subsidiary companies. A company cannot engage in the buyback of its shares via any subsidiary company, including its own subsidiary companies. This provision is intended to prevent companies from circumventing the restrictions on buybacks by utilizing their subsidiaries, ensuring that the financial transactions are transparent and comply with the regulations. Through investment companies. Similarly, a company is barred from buying back its shares through any investment company or a group of investment companies. This prohibition helps to maintain clarity in ownership and control, preventing potential conflicts of interest or manipulative practices that could arise from using investment entities for share repurchases. In case of defaults, the prohibition extends to situations where the company has made a default in various financial obligations. Specifically, a company cannot proceed with a buyback if it has defaulted on repayment of deposits accepted, regardless of whether these were accepted before or after the commencement of this act. Payment of interest on such deposits. Redemption of debentures or preference shares. Payment of dividends to any shareholders. Repayment of any term loan or interest payable thereon to a financial institution or banking company. However, the buyback may proceed if the default is remedied, and a period of 3 years has lapsed since the cessation of the default. This provision encourages companies to prioritize settling their debts and obligations before engaging in share repurchases. 2. Compliance with statutory provisions. Additional compliance requirements. No company shall purchase its own shares or other specified securities if it has not complied with the provisions of the following sections of the Companies Act. Section 92, relating to the filing of annual return. Section 123, pertaining to the declaration of dividends. Section 127, involving penalties for failure to distribute dividends. Section 129, relating to financial statements and their compliance with accounting standards. This stipulation ensures that companies remain compliant with their regulatory obligations and financial reporting standards before considering buyback activities, promoting responsible corporate governance. Importance of Section 70. The provisions of Section 70 serve several critical purposes in the corporate framework. Protection of creditors and stakeholders. By prohibiting buybacks under certain circumstances, the Act aims to protect the interests of creditors and other stakeholders. It ensures that companies fulfill their financial commitments before engaging in activities that could potentially diminish their capital. Encouragement of responsible corporate behavior. The restrictions encourage companies to maintain a sound financial position and prioritize the settlement of liabilities, thus fostering a culture of responsibility and ethical business practices. Regulatory compliance. By linking the buyback provisions to compliance with specific sections of the Companies Act, this section reinforces the importance of adhering to statutory obligations and promotes transparency in corporate governance.